Let's continue to unpack some more details surrounding the circumstances of this rape of a 7-year-old on a school premises in the Eastern Cape. Thousands have signed a petition calling for justice. To discuss this, I'm now joined by Busi Seabe, who is a social justice activist, and Sibongile Ndashe, Executive Director of the Initiative for Strategic Litigation in Africa. Good to have you, ladies, and thank you very much for coming on. Busi, let me begin with you. It's taken 5 months at least, if you count from October until now, for the Eastern Cape Department of Education to say they are now exercising the only option that they have, which is to deregister that school. Why do you think this has taken so long to come up to surface?
Thank you very much for having me. What we definitely know about this case and what we know about the department's failure to act swiftly is, in essence, to a large extent, schools are supposed to be places of safety, yet time and again, we see cases of abuse being ignored or mishandled. And when a child reports abuse or when abuse is reported, what we're able to see is that the Department of Education doesn't take urgent action to ensure that schools are safe spaces for children. So we need to start looking at whether schools are able to strengthen reporting and intervention systems by making, child abuse training mandatory for all teachers and staff. And we need to be able to also look at the individuals that are involved, particularly in this case, and the fact that it had to take a podcast and social media outcry for this case to essentially come out into the public in the way that it has. And the reality is that this case is not just an isolated one. When we look at the statistics, they paint a very grim picture, right? So when we look at the statistics from the SAPS, they reported to having around 5,342 cases of child murders, attempted murders, and assaults. And this is according to, Crime Stats SA. And when we look and we understand the fact that 1 in 3 children experience sexual or physical violence before the age of 18, we begin to understand that, the DNA backlog that is sitting at 53,000 cases nationwide is only but a result of a failing system that is collapsing under the weight of neglect and mismanagement. So right now, for example, in the Eastern Cape, where this case is centered, there are only just 12 functional child protection units in the entire province. And that means that only 94% of police stations, including possibly Matatiele's police station, lack the specialized officers needed to properly investigate child abuse. Yeah. And what we're finding is that the Department of Education does not have mechanisms in place to deal with perpetrators or to deal with issues relating to child abuse within that system. And that also leads to a large extent, a collapse of not only the education system, but also a collapse in the trust that parents have when they take their children to school.
Yes, Sibongile, what do we say to this? 4 months of investigation, but still no breakthrough. Of course, it seems there have also been hurdles that have been put in the place of the police to be able to get access to information. That, of course, in the context of a pandemic, if you like. The president had called it a second pandemic of gender-based violence against women and children. Sibongile, you're muted. If you can unmute for us, please.
Yeah. The information, so thank you. The information that's in the public domain right now is quite limited in terms of what has been done, to date. What we do know that in terms of the framework for responding to these issues is that in 2008, the Department of Basic Education issued a guideline for the prevention and management of sexual violence and harassment in schools. And what is important about this guideline is that even though there are gaps, it tries to provide guidance, to schools on what should happen when instances of child sexual abuse and harassment have been reported. So we know that we do have legislation on Sexual Offences Act. We know that we have the legislation on Children's Act. And we also have legislation that deals with employers, like Educators Act. All of these legislations, so there was an attempt, in this protocol, the guideline that's been given to schools, to say, let's look at the various legislative framework and see if we can provide you with guidance of what you need to do. So the first thing here that we need to ask ourselves, because when we talk about accountability, whether it is with the schools, whether it's with the Department of Basic Education or the various districts, is what is it that the guidelines or the law broadly say they must do that they did not do? So the first thing that we know about schools is that schools may have their own policies, but what is important is that there is a statutory obligation, like the law that was passed by Parliament. So there is a legal duty to report sexual abuse. And I think in part of the conversations that have been happening, it's that people are saying the school should have done more. So the question here is, did the school report the sexual abuse, and where did they report, this sexual abuse? Because if we are taking this to the police, because that's another agency, and in this case, it does look like an issue that requires the police to intervene, then the police have an obligation, right, to investigate. And so some of the things that the minister is talking about, when we are talking about DNA, Department of Women or Department of Basic Education, they are now out, of this. We are now talking about the South African Police Services. Yeah. And I think it is important to hear what the South African Police Services are saying about whether they have been able to conduct an effective, investigation. Yeah. Because we have got the tools, with the police. If someone is obstructing an investigation, they have got the powers, to deal with that.
So in an instance, Sibongile, like now, one of the letters that's on social media publicly, purported to be that from AfriForum to the SAPS, says that there has been a request for a buccal sample, for example, which those who are representing the principal are saying it's an irrational request at face value. What tools do the police have in that particular matter to be able to obtain that sample if they deem it's necessary?
So the question is, we do know that we cannot just get anyone's DNA, just because someone needs it. When we need a court order, then we can kind of get to a court order. But normally that happens to an arrested person, a person who has been charged, with a criminal offense. So what has the principal been charged? What's the case, against the caretaker or the driver or the school principal? So because it's the facts that actually leads us. So when the police are doing their investigation, that's when the prosecutor can actually help them to go to court and get, a court order. And that is why initially I'm talking about the quality of the investigation, because one, you don't want to botch the investigation, but it can't just be anyone who's just saying the principal must give us, the DNA. There has to be a legal basis for requesting, this DNA, whether it's the facts that are posting it, kind of that way. But if the facts are saying that's the thing, then that's when we are talking about the court order, and the police know how to go to court and get a court order that demands, that certain information be produced.
In this particular instance, Busi, it seems there's also a claim that the victim cannot, I suppose, at face value of those who are representing the so-called principal, identify who the perpetrator is. And that, of course, bringing us again to that conversation about how the justice system approaches these matters that have got to do with the abuse of children and women.
I just want to quickly start off by just responding to Sibongile when she brings up the framework that was released by the Department of Education in 2008. This is a framework that was released 17 years ago. We cannot be bound by a framework that, has been released 17 years ago that doesn't take into cognizance the need for surprise inspections to ensure compliance, that doesn't take into cognizance the need to advocate for stronger child protection policies, that doesn't take, the need for specialized school protection units within SAPS, and engaging with other departments as well to ensure, to a large extent, that they have access to the sexual offenders list, for an example. So we can't essentially look at this particular matter in reference to a 17-year-old framework that was put out by the department that hasn't been updated. And when we look at the SAPS and we look at the confinement that they have, we do definitely understand that Jacob Yeerdasa, which is the principal of the school, who's refusing to give his DNA sample, is currently being represented by AfriForum. And this is where the NPA comes into play, and the SAPS as well. They need to be able to investigate whether AfriForum is interfering in a criminal case. If they are obstructing justice or shielding a suspect, legal action must be taken against them. Any AfriForum member or leader that's involved in protecting a suspect must be criminally charged to an extent for preventing or perverting, to a large extent, the course of justice. And moreover, something that we need to be cognizant of is that if AfriForum is using donor funds or legal resources to protect a suspect, their supporters, need to be able to be brought to the forefront in terms of putting pressure for them to withdraw their backing so that we can essentially engage the suspect in a legal way that allows us to be able to a large extent, avoid the misuse of legal structures to shield criminals, right? And the government must also, to a large extent, review and possibly revoke AfriForum's ability to act as a legal representative in certain cases. And this is where we look at Parliament, right? And Parliament must also be able to consider stricter laws against individuals or organizations that knowingly protect child predators.
Sibongile, is there concern here that the politics, as we articulating now, some of the conversations that are going on social media could certainly cloud the legal processes that need to be followed in this matter and possibly end up, disrupting the whole process and the whole case?
Of course, we do see this. In a case of a 7-year-old being sexually violated brings up a lot of kind of emotions. But we are a country that works with the rule of law, that has got a constitution. And if there is something that's in the law that we do not like, then we have all the processes, to change that. I work in public interest law, and we ask ourselves this question all the time. It's like, why is this law the law? Are there gaps in the law? And then we go to court and we find a way to close that. So I'm just going to kind of push back a bit. This is not the United States under Donald Trump, where we have seen all of these executive orders against law firms that did things that he does not want or that he finds personally objectionable. If the school principal wants legal representation, that's a constitutional right for every person in the country, to get legal representation if he feels that his rights are violated. AfriForum may not be popular, with a segment of the country. Right now there's been quite a lot of things that have happened very recently, in terms of how they are using the law and also the kind of politics, that they are pushing, for. And I do think that when things like that actually happen, sometimes we find ourselves, in this position where we are kind of having these kind of responses, to it. There is nothing wrong about anyone seeking legal representation, and also people providing that legal representation if they are an institution that is there, to do that. But where I do agree is that it's the national prosecuting kind of authority that has to do that, because when we start acting in these ways that are populist, just responding to public sentiment, that's not necessarily, like following the rule of law, we don't only end up with bad precedent, but we just end up with decisions that are later, reversed by the courts, because it's like, is this what we were supposed to do? So there is a question right now about what Department of Education is doing in terms of kind of deregistering or closing the school. Is, have we followed what we need to do, in terms of if there's an obstruction of justice or there is an investigation that is ongoing, When is it that people are actually kind of summoned and forced to kind of come to court and explain certain things? And these is not the information that we are seeing, in the public, domain. So I do worry about issues that are like so sensitive, they are playing into the things that are very difficult and challenging in our country, race relations, gender-based violence and femicide. And how do we actually approach this when we actually do have processes in place? And finally, just because we have a law that's kind of safe, the guidelines is the framework. If there are gaps in the framework, our responsibility is to close that framework, but we do not discard the framework and say the framework cannot work. The conversation is, where are the gaps? And then, even as we implement the framework with the gaps, we say, by the power vested in us by the Constitution, we are going to say this is how we actually close the gap. Yeah. But we don't have the luxury to do away with things that we do not like, that are in the law.
Busi and Sibongile, much appreciated. Let's keep it there. Thank you for coming on. That is Busi Seabe, a social justice activist, and Sibongile Ndashe, Executive Director of the Initiative for Strategic Litigation in Africa.